You just received a settlement or an inheritance, and you realize that the receipt of that money is going to disrupt your need-based government benefits. Hi, I'm Darren Findling from the Probate Pro. This happens all the time. People receive money and they're worried that it's going to affect or impact their right to receive the need-based government benefits. What we're typically talking about is Social Security and Medicaid. And as you know, Social Security recipients are restricted as to the amount of money they can have in their account, as well as the amount of money that can come in the form of income. So a problem arises. Money is coming in from a settlement of an auto case or a negligence case or an inheritance, and the receipt of that money is going to disrupt the individual's right to receive Medicaid or Social Security. The goal with effective planning is to get the best of both worlds. Allow the settlement to come in and allow the recipient to continue to receive their need-based government benefits. The most common planning tool that most people are familiar with are supplemental or special needs trusts. These are vehicles that allow the money to come in and a trustee administers the money on behalf of that individual. But what happens if the amount of money is small or the individual won't qualify for some reason with a supplemental needs trust? So for example, the case settles for $20,000. After the payment of attorney fees and costs, the net amount of money is $11,000. Rather than the complexity of establishing a supplemental needs trust, the money can be spent down. That means divested of that individual and used in a manner in which it enhances that individual's life without affecting the individual's right to receive Social Security or Medicaid. We call that type of planning spend down planning. And it has to be done a certain way. And of course, like all good rules or regulations or laws, there are all sorts of rules relating to how the money can be spent. So for example, one of the general rules is that you can't use the money for the same purpose upon which the government is giving you money. So for example, rent is an impermissible thing to do a spend down with. And there's a list, and the list changes. But in general terms, we can be really creative with the use of that money and immediately spend it. So for example, maybe it's a prepaid burial or funeral. Maybe it's the purchase of an automobile or a car or furnishings to enhance that individual's life. This type of spend down planning needs the guidance of an experienced probate attorney who knows how to appropriately advise the individual of what is permissible on the spend down, as well as the reporting requirements, because even if you do things right, we want to make sure that you both maintain records and reporting is done correctly to avoid any disruption of the benefits that are coming in. I'm happy to answer questions to individuals who are receiving settlements or who are receiving inheritances or other lump sums to assist them in the most effective way to plan. A spend down plan is one of the very nice tools that we put in our toolkit to be able to appropriately plan for the individual who is receiving the settlement. If you have questions or want me to evaluate the situation, you're always welcome to call. You can speak directly to me. And you can call my office at 877-YOUR-FIRM. That's 877-YOUR-FIRM. Or, of course, you can go to our website, the Probate Pro, and you can email me, and I'm happy to answer questions and guide you. So don't be shy. Give us a call. I'll talk to you about spend down planning and see if I can be creative to allow for you to receive the settlement or inheritance and at the same time receive your need-based government benefits. Have a great afternoon, and it's my pleasure to assist you at the Probate Pro.